You're watching 13 WMAZ Law Call, sponsored by Macon Law Firm, Reynolds, Horn, and Servant. Your rights, your calls, live. This is 13 WMAZ Law Call.
Well, good evening, everybody, and welcome to Law Call. I'm Morgan Dukes, your host for tonight. And, COVID has been around for a year. Now, to say that, to some, you're saying, yes, I know, I felt every day of it. But if you are running a business, then you really feel the impact of it. And that's what we're going to be talking about tonight, COVID, the law, and of course, your business. And with me to help get this conversation going right is the lovely Kate Kerbo from Reynolds, Horn, and Servant. How you doing, Kate?
Hey, Morgan, I'm doing so great. I'm glad to be here and I'm excited about tonight's topic.
Well, you know what? Like I said, it's been around a year and some of us have felt every single day of it. But you did bring some help with you to help get into this conversation tonight.
I did. And I am so excited to introduce her because we actually went to law school. I have Miss Brittany Bennett, law school together. I have Miss Brittany Bennett. And just a little bit about Brittany, she went to Georgia State College and then to Mercer Law School, where we graduated together in 2016. Then she went on to practice. And in 2018, when her husband also graduated from law school, they opened a law firm together, which I think sounds like a dream. So I'd like everyone to meet Brittany.
Hey, Brittany.
Hi, how are you?
I'm good. Welcome to Law Call. And I'm excited to have all this girl power happening tonight. And certainly together, I think we can tackle a tough topic. And when we think about COVID and the law, people have a lot of questions about what they can do, what they can't do. Lots of things are coming out. So, Kate, let's start with you. How have things been in your law office with your practice? I mean, how has COVID really affected the way you communicate with your clients?
This is something that Brittany and I were talking about before the show, where, the law is very fortunate in that a lot of our practices are very adaptable. When the pandemic first hit and everything shut down, we shut down for a while. And then Zoom really had a tremendous impact on our practice. We're still doing mediations by Zoom, depositions by Zoom. If a client doesn't feel comfortable coming in to meet with us, we can set that up via Zoom. As far as just every day-to-day practices, we have re-implemented a mask policy. So we are masked at all times. And then as far as meeting with clients in person, it's just kind of a case-by-case basis. I tend to ask people if they've been vaccinated because I chose to get vaccinated. I, will let my mask down and sit 6 feet apart. But yeah, it's just it's a living thing.
Indeed, it is. Would you agree, Brittany? How are things in your office?
Yes, I would certainly agree. In our office, we haven't implemented a mask policy. It's really just kind of a case-by-case basis. I know that there's been an uptick in cases, but, we are able to, meet over the phone or via Zoom. And just like Kate was saying with, Zoom consultations or depositions or even Zoom hearings. Our courts here in Houston County have also re-implemented a mask mandate. But usually we just try to do whatever the client is most comfortable with. And since we're a smaller office, we're actually able to social distance really well. And then also just following CDC guidelines and, safety, sanitation. We sanitize our conference rooms, wash our hands, that kind of stuff. So being cautious, but also trying to kind of get back to normal as well. I know a lot of people are missing the in-person interaction. So when our clients want to come in and meet in person, we accommodate that as well. There are some things that I think that are just lacking in, these virtual meetings sometimes. So, with our clients, we want to make sure that they feel comfortable, whatever that might mean to them. So if it's a phone conversation, or consultation, we do that. And if they want to meet in person, then we wear our masks and social distance. So
now, Brittany, you just said something real interesting. You said when, some things might be lacking. And when you said that word, I got to thinking, is there anything that can happen in the world of law that might be considered lacking that might affect a person's case? I mean, can either one of you speak on that for a second? Because, since we don't have that personal interaction anymore.
Right. I think the biggest thing that it really affects is just client relations. So, when I represent a client, one of the main things that I, try to focus on is not just what's in the best interest of their case, but also, do they feel comfortable with the way that I'm representing them? And, it really is a unique relationship and every person is different. So the thing that is lacking in some cases is just that in-person, relationship and communication, some things that don't always come across virtually. And so I think that in some cases, it could hinder, not the case, but it could just hinder that relationship that attorneys have with their client, because we are in the service industry. So
you're so right, Brittany. That is so true, that every case is different. Every person is different. Every client is different. You're right. That interaction is so important. Kate, let's talk a little bit about the courts in your area. Are they open yet? How do you handle court cases or cases that need to go to court? How is that going to be handled?
We track cases in every area in Georgia, every county, and every county is doing things differently. Some counties are cautiously opening back up, like Bibb and like Brittany said, Houston, but some counties are still doing everything by Zoom. So I have attended in-person hearings at the courthouse, which has been really great after being shut down for so long, but I have also attended court right here from where I'm speaking to y'all. So it's certainly been an adjustment, and I haven't tried a case on Zoom. I haven't heard of anybody doing that. I haven't spoken to anybody that's had to do that, but I definitely agree with Brittany. I think that so much can get lost in translation when you're doing stuff online. It's like, they say you can't tell someone's tone from a text message. I kind of feel the same way. You gain so much by just sitting down face to face with a person and learning about them than you do, across a computer screen or across the email.
Okay. Well, speaking of emails, let's get to at least one email question before we go to break. And this is one that everybody has been talking about. Can my employer force me to wear a mask on the job or keep me from wearing a mask if I want to? Can I be fired for refusing the vaccine? That's such an important question, and it comes to us from Trey. And a lot of people are wondering just that, do I have to wear a mask? Is it going to affect everything?
Georgia is what's called an at-will state, right to hire, right to fire. So, we don't practice in this law. So unfortunately, or fortunately, Brittany's going to be doing a lot of heavy lifting on the show. But, my gut reaction just based on the law in Georgia is that, yes, your employer can force you to wear a mask or ask that you get the vaccine. And if you refuse right now, I'm thinking they can say do it or don't work here. Brittany, what do you think about that?
Right. Now, you're exactly right. Georgia's an at-will state. And, that means that your employer can fire you for any reason. And that would include, not wearing a face mask, failing to when they require it, or the vaccine. Now, but there are exceptions to that. So even though an employer can fire an employee for any reason, the exception is your employer cannot fire you for an illegal reason. And the EEOC governs that. So as long as your employer is not discriminating against an employee, or, failing to provide reasonable accommodations, under ADA, then, everything else kind of goes. But that does kind of lead me to, another interesting topic, so as far as refusing the vaccine, there's going to be exceptions to that too. So if an employee has religious beliefs, sincerely held religious beliefs, or, they have a medical condition that would prevent them from getting the vaccine, then the employer is going to have to accommodate that. And that accommodation, it might be requiring, that the employee wear a mask instead of getting the vaccine. It might be requiring that the employee work in a separate area away from other workers. It could be working from home. It would just depend on the type of work that an employee does and whether their job can be done in a different manner that would not hinder the business and still allow the employee to fulfill their job duties. But, like I said, also, as long as there's been, some sort of reasonable accommodation. And I would really encourage employers and employees to have the conversation, and employees to ask their employer if there is another way, if they don't want to get the vaccine, or, if they don't want to wear a mask, to have the conversation and interact with your employer. Most employers have an open door policy. They want to hear from you. I would encourage both employers and employees to have that conversation.
Okay. All right. Kate Kerbo, Brittany Bennett are our attorneys tonight. We're talking about COVID in the workplace. And when we return, we got more questions on the same topic. I'm Morgan Dukes, and you're watching Law Call.
You're watching Law Call on 13 WMAZ with personal injury attorney Carl Reynolds, who has recovered more than $500 million for his clients, dedicated to helping injured Georgians for more than 50 years, plus support from his Macon law firm of Reynolds, Horn, and Servant, including attorney Wendell Horn, focused on protecting the rights of car and truck wreck victims across the state, and attorney B.J. Servant, aggressively representing those injured by medical malpractice, hosted by award-winning broadcaster Morgan Dukes, featuring guests from across Middle Georgia. Your rights, your calls, live. This is Law Call on 13 WMAZ.
And welcome back to Law Call. I'm Morgan Dukes, your host for this evening, and we're talking about COVID in the workplace and the law. All three are happening right now in this day and time that we're living in. But we have from Reynolds, Horn, and Servant, Ms. Kate Kerbo to help us answer some questions tonight, as well as Ms. Brittany Bennett. Both of these wonderful attorneys have some answers, and many of you have submitted your questions. So let's get to it, because somebody wants to know how to handle COVID when it walks in the door. And that's exactly Sherry's question. Sherry sent in an email that says, my son was exposed to COVID at work, and he only found out from the sick boy. Now, his employer never told any of the other workers. Wow. What are the employer's responsibility as far as keeping employees safe from COVID? Brittany, this is such a good question. I mean, help us out here.
It is a great question. It would definitely depend on some of the circumstances and some of the facts. In this particular scenario, the son, was exposed, but at the same time, was the other employee symptomatic, asymptomatic? Was he contagious? Was he not contagious? Did the employer, I guess it kind of raises more questions. Did the employer isolate the other worker so that way, it wouldn't further spread? Was the boy wearing a mask? That kind of stuff. But at the same time, as far as an employer being responsible, as long as the employer is following the CDC guidelines and the proper protocols, there's only so much an employer can do. And they're certainly not an insurer of safety. We all know COVID is out there. It's at playgrounds, it's at libraries, it's at schools. It's at the grocery store. But as far as what your employer is responsible for, they can only do as the best that they can, just like everybody else, so, they're not an insurer of safety. And I think that, this would really be similar to, maybe like a premises liability case. And I think, it's that same level of care. As long as employers are implementing policies where they are protecting their employees to the best of their ability, then that same standard of care applies. And that would be ordinary care to, stop the spread or, help prevent, the further spread to the best of their ability.
Now, Kate, let me ask you this question. Does workers' comp cover COVID in the workplace?
No, not right now. There is no action that can arise from COVID right now. And that, that COVID statute, I think the immunity was expired on July the 15th, but that's a living statute. It's a living disease that's going to change over time. They may put that back into place. And, going back to Brittany's answer, I would think that, there would be some privacy concerns that would come into play as well. Does an employer have a duty to disclose someone's health status? Do they have a duty to inform the entire office, Joe came down with COVID? I don't know. I don't know what the issue would be there. Or I don't know what the answer would be there, but I think that would come into play as well, because you think about, we have a bad flu season every year. And, there is no duty to inform the entire office if someone comes down with the flu. So I think that we're certainly going to see a lot of litigation stemming from this, and a lot of different areas are going to come into play that you wouldn't necessarily think about.
I totally agree, because I know someone that very same thing just happened. Unfortunately, they died as a result of it, but the person that they came in contact with on the job who had it, who, transmitted it to them, did come forward and let everybody know on the job that this happened. And unfortunately, the person was gone within a week and a half, which was also quite amazing. Now, you mentioned something expired, the date of, was it July 15th? What did you just say? Expired?
Yeah, the immunity that the COVID statute provides expired on July the 15th. And when you're going into just about every public place, they have the COVID statute posted on their door in a certain bold lettering that's required by the statute, stating basically that you're entering at your own risk and that the business can't be held responsible. And it's my understanding, and I don't know for certain, it's my understanding that the immunity for that statute expired on July the 15th. And I would assume that the Georgia legislature is revising it now. And with the Delta variant and the uptick in, COVID infections, that it's going to be put back into place at some point. But that's just what I heard through the grapevine. Brittany, had you heard that?
I haven't heard whether they're going to, revise it or extend it. I think it should be extended. I think that initially when that statute was enacted, the legislature probably thought that, coronavirus would be gone by now. So I think that was probably the reason for the expiration. It just wouldn't be needed at this point. But with the Delta variant, and obviously the pandemic is, ongoing and has continued, I think that it actually, would certainly warrant the extension of the statute and to limit liability for employers. Because like I said earlier, the virus is everywhere, so I think it would be very difficult for a plaintiff to even show that they contracted it from a particular business. And, you might be more familiar with, with the burden of proof with something like that, with, that type of liability. But I think it would just be very hard for a plaintiff to even, show that that's where they contracted the virus. I mean, because unless they could somehow show that they have been in their house every minute, and no visitors, or, something like that, a very, isolated situation, it would just be very difficult. And I don't think that employers should bear the burden of, providing some sort of relief when, they're doing the best they can, just like everyone else.
All right. Kate Kerbo, Brittany Bennett, those are our attorneys tonight. I'm Morgan Dukes, and we'll be back with more right here on Law Call. If you have further questions for Brittany Bennett, you can find her at Bennett Law and Mediation Services, LLC in Warner Robins. The phone number is 478-328-8316, or you can find her online at www.bennettlawga.com. If you have a question for Ms. Kate Kerbo, you can find her at Reynolds, Horn and Savant right here in Macon. Phone number is 478-405-0300. And you can also find them on the web at www.reynoldsinjurylaw.com. And don't forget to follow Reynolds, Horn and Savant on Facebook. All right, ladies. We're talking tonight about COVID, the law, and the workplace. And since we're all working women, that is a real possibility that we may encounter it at some point. So let's get back to questions. And Quincy has sent in a very good question. He wants to know, my boss announced that they're going to start taking everybody's temperature before we start our shift. I get it. He says he understands it, but is it actually legal for them to do that? Is that some kind of invasion or some kind? What do you say, Kate?
I would say it's absolutely legal. They're just, like we were discussing earlier, they're doing their part in following the CDC guidelines, and they can only do, what they can do. And I know I sound like a broken record, but Georgia is an at-will right to fire state. So I think they can absolutely say, let us take your temperature or don't work here. It's your choice.
Brittany?
Right. Kate's exactly right. The ADA actually has a little bit of guidance on this as well. And what the ADA states is that if, as long as the, medical examination, that's how it's termed and that's how it's phrased in the ADA, as long as the medical examination is job related and a business necessity, then your employer can require, either like a physical, they can take your temperature. Now to how far that goes, I'm not sure. And until somebody, files a suit against an employer and says, no, this is an invasion of my privacy, then that is the law right now. They are absolutely allowed to take your temperature as long as it's, like I said, job related and a business necessity. And so far, there has been no case that I'm aware of that has shown that taking temperatures during this pandemic is not job related or a business necessity. Now, it would be a little bit different, I think, if an employee was working virtually and your employer knocks on your door and wants to take your temperature. Now, I think that would be a little bit different because then, they're coming to your house. Well, that might be an invasion of privacy, right? And then if you're working virtually, it might not be a business necessity. It wouldn't matter if you have a fever or if you have symptoms at that point because you're not around other people. So I think that there are some facts that could change the outcome and change the answer, obviously. But with this scenario, yes, absolutely, it is legal.
All right. Well, listen, here's a question from Amanda that is going to require a short answer, but it's a lengthy question. So here we go. I was laid off from my job 6 weeks ago, filed for unemployment. I still haven't received my benefits. And if they don't pay me my unemployment or back pay, do I have a lawsuit? Now, I know that's there could be a lengthy answer to that question, but what's the short version of the answer?
Brittany, I'm going to toss that one right to you. That's your area of expertise.
Sure, absolutely. So in this scenario, it would really just depend. Back pay is a different action altogether. When you're talking about unemployment, an employee is eligible for unemployment if they were fired through no fault of their own. So that's the rule of thumb there. But if you just haven't received it yet, it would depend on if you have filed all the proper paperwork. And that comes from the Department of Labor. It goes through the Department of Labor, not your employer. So as long as you filed with the Department of Labor, then you should be good to go. So, but in that same breath, though, there is a lot of backlog with government agencies right now because of the pandemic, because they employ people just like other employers. And so they're facing the same challenges as well.
Okay. All right. Kate, any last thoughts on that? Because, a lawsuit is a lawsuit. Should they call you?
Yeah. If they have questions about unemployment, they should absolutely call Brittany.
Okay. Well, so on that note, Brittany Bennett, thank you so much for being with us tonight. Kate
Thank you so much for having me.
You're quite welcome. Kate, it's always so good to see you. Always. Little girl power happening tonight on Law Call. Listen, we want to thank each and every one of you for watching as well. So from all of us here at Law Call, I'm Morgan Dukes. Good night, everybody. Have a good one. We'll see you next time. All right. Thanks for watching Law Call.